Mr. Frills then came up to Miss Robertson, who was stuck in her vehicle, and told her to tell the police his grandmother had been the one driving the car, and then subsequently ran off.
Welcome back to another intense courtroom breakdown. Today's case is a wild ride of reckless driving, deception, and a desperate attempt to dodge responsibility. We're looking at the case of Joseph Matthew Fells, a man accused of driving under the influence, causing a devastating head-on collision, and then trying to convince his victim to lie for him. Yes, you heard that right. After smashing into a woman's car not once, but twice, he allegedly approached her while she was trapped and told her to blame his grandmother as the driver. Imagine the audacity. But that's not all. Fells isn't just facing a single charge, he's looking at multiple counts, including DUI, reckless aggravated assault, and felony evading arrest. In this courtroom session, we'll watch as the judge walks him through the serious consequences of his plea. The victim delivers a gut-wrenching impact statement, and the law comes down hard with strict sentencing. Stick around, because the twists in this case, from the evidence found at the scene to the emotional words of the victim, paint a chilling picture of reckless disregard for human life. And trust me, you'll want to see how the judge ties it all together at the end.
Frills is charged here on a criminal information. Mr. Wanick, you represent him?
I do, Judge, and we have a plea worked out.
All right.
I just need him to sign.
All right. Thank you.
Judge, this is a criminal information. It's a 3-count. There's 3 charges. Pursuant to the agreement, Mr. Frills will plead no contest. And on count 1, that is a DUI first offense. He'll receive 11 months and 29 days in the county jail. That is to be served day for day. He'll receive a $350 fine plus court cost. He will have his license restricted for, he'll have his license suspended for 1 year. He'll be eligible for a restricted license.
This is where the weight of a DUI really comes crashing down. Notice how the judge carefully outlines not just jail time, but also fines, mandatory assessments, and even the loss of a driver's license. For many, losing the right to drive for a year can be just as life-altering as jail. And here's something crucial: when the judge says day for day, that means there's no early release, no shortcuts. Every single day behind bars has to be served. That's a serious blow. What do you think? Does a 1-year sentence feel like enough for someone who not only risked lives but also tried to manipulate the truth at the scene?
You'll have to have an alcohol and drug assessment and complete a victim impact panel. He will count 2 is reckless aggravated assault. He'll receive 12 years suspended to community corrections. That is consecutive to count 1. Count 3 is felony felony evading, and he'll receive 6 years. That will be consecutive to count 2. Concurrent to count 2, excuse me, for a total of 12 years suspended community corrections after serving the 1129 on count 1.
All right, Mr. Frills, raise your right hand. Let's place you under oath. Thank you. State your full name for the record.
Joseph Matthew Frills.
Mr. Frills, you are here today on a criminal information. I want to make sure you understand what that means. Every person who is charged with a criminal offense carrying the possibility of incarceration has the right to have their case and the evidence against them reviewed by the grand jury of the county where the offense is alleged to have committed. The grand jury is an independent body that reviews the evidence and determines whether there's probable cause to return a formal charge against an individual. You have the right to waive that step and expedite the entry of a disposition in your case. And by doing that, you sign off on a criminal information. I've been handed a criminal information that indicates that you wish to do that. Is that correct?
Yes, sir.
All right. And you understand that he needs to sign off on the waiver of his indictment and criminal information. So He needs to sign it. You need to sign it as well, Mr.
I apologize for
Winnick.
what I did. Oh,
Well, I'm sorry, there was a waiver of indictment signed by the two of you.
A plea of no contest is always fascinating. It's not an admission of guilt, but it accepts the punishment as if guilty. Why would someone do this? Simple, avoiding the full fallout of admitting wrongdoing while still taking the deal. But here's the twist. This plea still stacks convictions on his record, meaning if he reoffends, the penalties will skyrocket. It's like saying, I'm not fighting this, but I'm also not confessing. Do you think this was a smart legal move, or just a desperate attempt to avoid a trial that might have gone even worse?
Never mind.
We need
We
to
have
sign
a
this?
signed indictment. I was given a copy of that, and it did not have the signatures on it, so. All right. Mr. Friels, I've also been handed a document indicating that you want to enter a plea of nolo contendere, which means no contest to those three counts that Mr. Winnick has gone through. Do you understand that means you're not going to admit you did anything, but you're not going to contest the state's evidence? And I will then hear from the state about their evidence, and that evidence will support a finding of guilt in your case. Do you understand that?
Yes, sir.
You understand, however, that what you're charged with, and if you and Mr. Winnick had an opportunity to discuss the range of punishment you're facing as well as any possible defenses you might have to the charge.
Absolutely.
Well, it's indicated that you want to enter this plea of no contest. Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
You understand that if you went to trial, you'd have the right to have a lawyer and to have one appointed if you could not afford your own.
Yes, sir.
You understand that if you went to trial, you'd be presumed to be innocent until such time, if ever the state proves your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand that you would be presumed to be innocent at trial. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
I do.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading a no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyers worked out.
Yes, sir.
Do you understand that's going to result in several convictions that are going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime?
Yes, sir.
You understand everything I've explained to you?
Have.
Do you want to plead no contest according to this agreement?
Plead no contest.
Is your decision to plead no contest today voluntary?
It is.
Anybody forcing you to do this against your will?
Sure.
You understand I cannot accept your plea unless I'm satisfied that you are guilty and there are facts to support it.
You understand?
And I want you to listen as the state tells me what their evidence would be if this case went to trial. Step aside for the district attorney, please.
Your Honor, if this were to go to trial, the state would intend to show, we'll start with count 3 since it's the older in time. On or about July the 8th, 2023, Officer Brent Allen with White Bluff Police Department observed Mr. Friels get into his F-150 truck after exiting a convenience store in White Bluff, where he knew Mr. Friels to have a revoked license. Officer Allen came up behind Mr. Friels on the road and activated his lights for a traffic stop, but a pursuit ensued instead. With Mr. Friels going into multiple lanes of traffic, Officer Allen did terminate the pursuit due to safety concerns. These events did occur in Dixon County.
And here's where the full picture of danger comes out. A high-speed chase, weaving through lanes, refusing to stop, that alone is reckless. But when you add the head-on crash with Miss Robertson and the fact that he hit her car a second time, it paints a terrifying scene. And let's not overlook what was found in the vehicle, a meth pipe and THC wax. That detail cements what officers suspected. He wasn't just reckless, he was impaired. Imagine being in Robertson's shoes, trapped in her car, while the man responsible tells you to cover for him. This isn't just criminal, it's deeply disturbing.
For purposes of counts 1 and 2, on or about June 3rd, 2025, Trooper Dyer with Tennessee Highway Patrol responded to a wreck with injuries at or around 3408 Trace Creek Road in White Bluff, Tennessee, here in Dixon County. An investigation determined that Mr. Friels had operated an F-150 at a high rate of speed in the wrong lane and did strike a car driven by Ms. Stephanie Robertson head-on. After this initial impact, Mr. Friels then pulled forward and struck her again. Mr. Friels then came up to Miss Robertson, who was stuck in her vehicle, and told her to tell the police his grandmother had been the one driving the car, and then subsequently ran off. Miss Robertson and another witness on scene did observe Mr. Friels to show signs of impairment from illicit drugs. Miss Robertson was able to identify Mr. Friels in a photo lineup. Trooper Dyer did locate a suspected meth pipe and THC wax in the vehicle, and Mr. Friels abandoned on scene. Trooper Dyer was able to call Mr. Friels on the phone. Mr. Friels stated he had gone to Vanderbilt for his injuries, but Vanderbilt reported Mr. Friels had never come to any of their facilities. Ms. Robertson did sustain injuries in this matter, which is the basis for the reckless aggravated assault. Just for the record to note, under 4035-501cc, the reckless ag assault is 100% should he violate community corrections. I know that he's been told that by counsel, but I just want to make sure it's noted on the record.
Did you catch that phrase? Career offender. That's a game changer. This isn't a one-time mistake, it's a pattern. Courts treat career offenders with far less leniency because the law sees a history of poor choices, not just a single lapse in judgment. That's why the sentencing sounds so steep. And it's worth asking, how many chances should someone get before the system says, enough is enough? Drop your thoughts in the comments. Should repeat offenders get harsher sentences right away, or should every case be judged as a fresh start?
The state also notes that Mr. Friels is to have no contact with Ms. Robertson as part of that community corrections. Mr. Friels is a career offender, and which is why he is receiving the sentence that he is receiving. Ms. Robertson is aware of the settlement and is here today. She has approved this settlement, and she is here to read off a statement that she has written in this case.
Now, Mr. Friels, I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial?
I do.
Are you satisfied with your attorney's services? Do you believe that Mr. Wainick has done a good job of representing you competently? Mr. Wainick, you know of any reason you should not enter the plea?
I do not, Judge. I do want to add one thing, though. I was appointed to this case in general sessions. We worked out the criminal information there. That's why I'm announcing that here. The charges in general sessions are to be dismissed after he enters his plea.
All right. Then, Mr. Friels, you and Mr. Wainick have a seat over here and let the victim impact statement be made, please. I'm going to let her come to the witness stand if you don't mind.
Okay. Ma'am, please state your name.
My name is Stephanie Robertson.
And do you have a statement to read to the court today?
I do.
You may read it whenever you're ready.
My name is Stephanie Robertson, and I am the victim of a hit-and-run accident that has left a lasting impact on my life physically, emotionally, and financially. Since the day of the crash, I have felt a deep sense of uncertainty and anxiety when getting behind the wheel. Driving, which is part of my daily routine to see the patients in the community as I work for hospice, now feels stressful. Being left in the car while you ran off like you did.
This is the moment where the courtroom shifts from legal language to raw human emotion. Miss Robertson's words cut deep. She describes thinking she might never see her children again. That's the kind of trauma that lingers long after the physical injuries heal. Her statement reminds the court, and all of us, that these crimes aren't just numbers on a charge sheet, they devastate real lives. Notice how she also touches on financial strain and long-term anxiety behind the wheel. A single reckless act doesn't just fade away, it follows victims every single day.
I'm sorry. Made me fearful and thinking of the day, that was the day that I was going to reunite with my two children in heaven. No one should ever have to feel that kind of terror or helplessness that you left me with that day. The incident has also left me with financial strain. Even with the insurance and the gap, some of the car was not fully paid for. Also having to replace the Kia and continue to work, the financial burden is still present. I hope the courts take into consideration that I am somewhat young and was able to sustain the multiple hits that you placed on my car that day. I can't help but wonder, what if this had happened to someone more physically vulnerable, like an elderly person? The outcome could have been much worse. The hit and run was not just an accident, it was an act that showed no regard for human life, safety, or responsibility. I'm asking the court to recognize the seriousness of what has happened, not just for me, but for the message it sends to others. Thank you guys so much for your time today.
Thank you, Ms. Robertson. That is it, Your Honor.
Thank you. Mr. Friels, come back to the stand, please. Joseph Matthew Friels, in docket number 2025 CR 240, upon your plea of no contest to count one, I find you guilty, sentence you to 11 months and 29 days in the county jail to serve day for day. You're ordered to pay a $350 fine and costs. You're ordered to undergo an alcohol and drug assessment and follow the treatment recommendations. You're also ordered to attend the victim impact panel and have an SR22 for insurance. Your license will be lost for 1 year. We have the I don't believe you've gone over with him the DUI enhancement provisions. Is that correct?
I apologize.
Yeah, I have the DUI enhancement form, please. I'm required by law to advise you of the following in open court. Any person who is convicted of a first offense driving under the influence shall be fined not less than $350, no more than $1,500, and shall be confined in the county jail or workhouse for not less than 48 hours, no more than 11 months and 29 days. Shall be prohibited from driving in Tennessee for 1 year, provided that if at the time of the offense the alcohol concentration in such person's blood or breath is 0.20% or more, the minimum jail sentence shall be 7 days instead of 48 hours. Any person who is convicted of a second offense shall be fined not less than $600, no more than $3,500, and shall be confined in the county jail or workhouse for not less than 45 days, no more than 11 months and 29 days. Shall be prohibited from driving in Tennessee for 2 years. Any person convicted of a third offense shall be fined not less than $1,100, no more than $10,000, shall be confined in the county jail or workhouse for not less than 120 days, no more than 11 months and 29 days, and shall be prohibited from driving in Tennessee for not less than 6 years. Any person convicted of a fourth offense shall be guilty of a Class E felony, shall be fined not less than $3,000, no more than $15,000, shall be confined for not less than 150 consecutive days, no more than the maximum punishment authorized for the appropriate range of a Class E felony, shall be prohibited from driving in Tennessee for 8 years. Any person convicted of a fifth offense shall be guilty of a Class D felony and shall be fined not less than $3,000, no more than $15,000.
That line, "What if this had happened to someone elderly?" is chilling. Robertson makes a powerful point. She survived, but someone more vulnerable might not have. That's why sentencing isn't just about punishing the offender, it's about sending a message. Driving under the influence isn't just risky for you, it's gambling with the lives of everyone else on the road. Her words add weight to the judge's decision and show why victim voices in court are so crucial.
Shall be confined for not less than 150 consecutive days, no more than the maximum punishment authorized for the appropriate range of a Class D felony. Shall be prohibited from driving in Tennessee for 8 years. Any person convicted of a sixth or subsequent offense shall be guilty of a Class C felony. Shall be fined not less than $3,000, no more than $15,000. Shall be confined for not less than 150 consecutive days, no more than the maximum punishment authorized for the appropriate range of a Class C felony, and shall be prohibited from driving in Tennessee for 8 years. Any person convicted of any offense while accompanied by a child under 18 years of age, the person shall be fined $1,000 in addition to the fine for the DUI offense. It shall be confined for a mandatory minimum period of 30 days, which shall be served in addition to any period of incarceration received for the DUI offense. If the child suffers serious bodily injury as a proximate result of the DUI offense, the person commits a Class D felony and shall be punished for vehicular assault as provided in TCA 39-13-106. If the child is killed as a proximate result of the DUI violation, the person commits a Class B felony and shall be punished for vehicular homicide involving intoxication as provided in TCA 39-13-213 subsection B2. In addition to the required sentencing, a judge may order substance abuse treatment, substance abuse assessments, conditions of probation, and monitoring with periodic reporting using one or more of the following: transdermal or other alternative alcohol or drug monitoring device, electronic monitoring without random alcohol or drug testing, global positioning monitoring system. In determining whether a conviction is a second or subsequent offense, it does not matter whether the prior offense occurred in Tennessee or in another state. In determining whether a conviction is a second or subsequent offense, all prior convictions within the past 10 years from the current conviction shall be considered. If the person's current conviction is within 10 years of the previous conviction, the person shall be considered a multiple offender. If the person is considered a multiple offender, then all convictions within 10 years of the date of the immediately preceding conviction shall also be considered in determining the number of prior offenses. For purposes of determining if a person is a multiple offender, the state may use a conviction for an offense committed in another state that would constitute the following if committed in this state: driving under the influence, boating under the influence, vehicular assault, aggravated vehicular assault, vehicular homicide, or aggravated vehicular homicide. The state may also consider an offense committed in another state as a prior conviction if the elements of the offense are the same as the elements of the comparable offense in this state. For purposes of determining if a person convicted of DUI is a multiple offender, a prior conviction for boating under the influence, vehicular assault, aggravated vehicular assault, vehicular homicide, or aggravated vehicular homicide shall be treated the same as a prior conviction for DUI, as long as the person was convicted of the prior offense before committing the instant violation of DUI. A defendant's automobile may be subject to seizure and forfeiture upon a second or subsequent conviction of a DUI offense. Unless a person convicted of violating TCA 5510-401 is determined to be indigent, the minimum applicable fine shall be a mandatory and shall not be subject to reduction or suspension. All fines are subject to be paid on the date sentence is imposed, unless the court makes an affirmative finding that the defendant lacks the present ability to pay. The court shall then order a date certain before which payment shall be made. Should the defendant fail to comply with the order of the court, the clerk shall notify the court of the failure for further proceedings. The payment of restitution to any person suffering physical injury or personal loss as a result of such offense, if the person is economically capable of making such restitution, shall be imposed as a condition of probation under TCA 5510-410. I need you to sign that and date it along with your lawyer to indicate that that has been read to you in open court. Count 2, you're found guilty of reckless aggravated assault and sentenced to 12 years in the Tennessee Department of Corrections. That will be suspended to community corrections consecutive to count 1 when you're going to serve that 11 months and 29 days, day for day. And that will be at 100% release eligibility. What that means is that when you're released from jail, you violate one rule of probation one time, and you will go to jail, go to prison for 12 years, and that will be 12 years to serve, not 12 years at 30% or any of that. You'll serve 100%. You understand that? Count 3, you're also ordered to pay court costs on count 2. Count 3, you're found guilty, sentenced to 6 years. That will be suspended to community corrections, and concurrent to count 2. All the pending General Sessions Court cases were to be dismissed as a part of this agreement, and court costs, as I've said, will be ordered. We get credit from August 28th of 2025 until today. That's the judgment of the court. Thank you. I will say this, Mr. Friels, you're lucky that you're not being charged for vehicular assault, vehicular homicide, or something more serious. Ms. Robertson has made it clear that she wants the court to recognize the seriousness of it, and I do. I think the district attorney has recognized it because a 12-year sentence is nothing to sneeze at. By the same token, as I've indicated to you, for the next 12, 13 years of your life, you're either going to be in jail or you're going to be on intensive probation. And you violate one rule one time, and it will be easy for this court or another court to send you to serve that 12 years. All right, that's the judgment. Thank you.
And there it is, the hammer drops. Joseph Matthew Fells is officially convicted. jail time, fines, license loss, and a massive 12-year suspended sentence hanging over his head. Here's the key takeaway: that suspended sentence isn't just a warning, it's a loaded gun. If he violates even one condition, he's going straight to prison for the full term, no reductions, no parole games. This case highlights the balance courts try to strike, punishing past actions while giving one last chance for rehabilitation. But what do you think? Should he have gotten that chance, or should the court have locked in the full 12 years immediately? Let us know in the comments. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts.